The illusion of the finish line. For decades, millions of immigrants in the United States have viewed the naturalization ceremony as the ultimate finish line. Taking the oath of allegiance was meant to be the moment the waiting ended, the interviews stopped, and the paperwork was finally filed away for good. Citizenship was synonymous with permanence and security, a legal shield that protected your status as an American, regardless of which political winds blew through Washington. However, as we enter 2026, this foundational assumption is being challenged in a way we haven't seen in generations. A new legislative push, combined with a radical shift in enforcement priorities, is testing the promise of permanence that naturalized citizens have relied upon to build their businesses, homes, and families. The immigration journey, once thought to be over, may be reopening for thousands of Americans. Defining the Scam Act of 2026. The central driver of this uncertainty is the Stop Citizenship Abuse and Misrepresentation Act, or the Scam Act. Introduced in January 2026 by Senator Eric Schmidt and Representative Tom Emmer, the bill is framed by supporters as a necessary reform to protect the integrity of the naturalization process by closing dangerous loopholes. The timing of the bill is significant, appearing when immigration enforcement has become a central priority of the current administration. While supporters argue it merely targets bad actors who abuse the system, critics warn that the bill's broad language could transform naturalized citizenship from a permanent status into something conditional and revocable. This debate moves beyond abstract policy. It touches the core of what it means to be a member of the American political community. The traditional shield, current law on denaturalization. To understand the magnitude of the Scam Act, we must first look at the legal standards that have historically protected citizenship. Under current federal law, denaturalization, the process of revoking someone's citizenship, is designed to be an extraordinary remedy reserved for extreme circumstances. For decades, the government could primarily pursue these cases only if it could prove that citizenship was illegally procured or obtained through willful misrepresentation of a material fact during the application process. The burden of proof has always been exceptionally high, requiring the government to present clear, convincing, and unequivocal evidence. This narrow focus ensured that minor clerical errors, innocent misunderstandings, or conduct occurring long after the oath was taken could not be used to strip an American of their status. The bright line, timing, and post-naturalization conduct. A fundamental pillar of current law is the bright line drawn at the moment of the oath. Traditionally, if a naturalized citizen commits a crime years after becoming American, they are punished under criminal law just like any other citizen, through fines, imprisonment, or probation. However, their citizenship itself remains intact because the misconduct occurred after they were admitted to the political community. The logic is simple. Once the immigration chapter is closed, your status is no longer tied to ongoing behavioral conditions. The Scam Act proposes to blur this line by allowing the government to look at conduct that occurs well after naturalization has been granted. This shift would effectively end the era where citizenship marked the permanent end of a person's conditional relationship with the government. Expansion of fraud grounds. The at any point. Rule 1 of the most significant changes proposed in the Scam Act is the expansion of what constitutes grounds for revocation. Currently, the fraud must be tied directly to the citizenship application itself. The Scam Act, however, explicitly includes material fraud committed against the United States government at any point. This broad phrasing could encompass benefits fraud, tax fraud, or immigration petition fraud on behalf of family members occurring years after the person became a citizen. Under this framework, a naturalized American who makes a serious error on a federal application a decade after their ceremony could find themselves facing a civil action to revoke their citizenship in addition to standard criminal penalties. Aggravated felonies as a standalone trigger. Under the proposed legislation, the conviction of an aggravated felony would become a standalone ground for denaturalization. In our current system, a naturalized citizen convicted of a serious crime, such as large-scale fraud, drug trafficking, or violent offenses, faces the same justice system as a natural-born citizen. Their citizenship is generally safe because the crime did not involve lying to get that citizenship. The Scam Act would change this, allowing the conviction itself to trigger proceedings to strip the person of their status, regardless of how long ago they took their oath. This transforms citizenship into a status that is contingent on a lifetime of good behavior, a standard that does not apply to citizens born on U.S. soil. National security and the elasticity of affiliation. The SCAM Act also seeks to broaden the language regarding affiliation with terrorist organizations, espionage, and transnational criminal enterprises. While some of these grounds exist today, they are usually tied to the concealment of such memberships during the naturalization process. The new bill would codify and expand these grounds, potentially allowing for denaturalization even when the connection to the original application is less direct. Analysts and civil liberties advocates are concerned about the elasticity of terms like affiliation. In a highly charged political climate, vague definitions can be stretched, allowing the government to target individuals based on associations that may not have even existed at the time of their naturalization. The 10-year statute of limitations. A particularly controversial element of the SCAM Act is the introduction of a 10-year statute of limitations for certain post-naturalization conduct. Historically, the longer a person remained a citizen without issue, the more secure their status was presumed to be. This new provision reframes that assumption, creating a decade-long vulnerability window. If a qualifying offense, such as material fraud against a federal agency, occurs within 10 years of becoming a citizen, the government would have the explicit authority to initiate denaturalization. For millions of Americans, this means the file they thought was permanently closed would remain legally open and subject to review for a significant portion of their adult lives. Shifting evidence standards and evidentiary flexibility. Beyond the grounds for revocation, the SCAM Act addresses how evidence is evaluated in these cases. Supporters describe these changes as clarifications to make enforcement more practical, allowing prosecutors to rely on a broader range of documentary and circumstantial evidence. However, critics worry this language could effectively lower the evidentiary threshold in real-world applications. Because denaturalization is a civil proceeding rather than a criminal one, it does not require proof beyond a reasonable doubt. Any shift that makes it easier for the government to win cases based on ambiguous records or minor inconsistencies in old files carries serious consequences for the stability of naturalized status. The bureaucratic shift. Proactive file reviews. While the legislation is being debated in Congress, a parallel shift in enforcement philosophy is already happening within federal agencies. Reports from legal observers and former officials suggest that USCIS field offices have been encouraged to review old naturalization files more proactively. Instead of passively responding to specific tips about war crimes or major fraud, officers are reportedly being asked to look for potential cases. This move from reactive to proactive enforcement signals a fundamental change in how the bureaucracy views its mission. A system once designed for exceptional, rare cases of egregious misconduct is starting to function more like a regular enforcement pipeline. Analyzing the internal targets. The 2000 case. Goal. Perhaps the most alarming data point for naturalized citizens is the scale of the enforcement already being discussed behind the scenes. Historical averages for denaturalization have hovered around a dozen cases nationwide per year, a number that made the threat almost statistically invisible to the 26 million naturalized Americans. However, internal targets discussed within the system in 2026 reportedly aim to generate between 100 and 200 referrals per month. If these targets are met, the U.S. could see more than 2,000 cases annually, representing a nearly 100-fold increase over historical norms. When a bureaucracy operates under numerical expectations, the incentive often shifts toward finding cases rather than waiting for them. Borderline situations and ambiguous records. In a high-volume enforcement environment, borderline situations that might have been dismissed in the past may now move forward. Naturalization applications are notoriously complex, requiring precision on everything from travel histories and employment timelines to name variations over several decades. Minor discrepancies can occur for completely innocent reasons such as memory gaps, translation issues, or clerical errors. Under the current high evidentiary threshold, these rarely led to denaturalization. But if officers are proactively reviewing thousands of files looking for referrals, these ambiguous records may receive unprecedented scrutiny. For the individual, this means having to defend their citizenship in federal court over a decades-old mistake. Case study. The benefits error scenario. To understand how these changes might impact ordinary life, consider a person who naturalized 12 years ago and during a period of financial hardship 3 years later made an error on a federal benefits application. Under the current traditional framework, that mistake, while perhaps resulting in a penalty at the time, would not jeopardize their citizenship because it didn't involve fraud during the naturalization process. But under the Scam Act, if characterized as material fraud within the 10-year window, that same administrative error could become the basis for a denaturalization referral. Even if the person ultimately proves they had no intent to deceive, they would still have to endure a federal lawsuit and the potential collapse of their sense of security. Case study: the post-oath felony. Another realistic scenario involves a naturalized citizen convicted of an aggravated felony, such as a large-scale fraud conviction, 5 years after their ceremony. Under current law, this person pays their debt to society through the criminal justice system, but their citizenship remains intact. The Scam Act would allow the government to seek a second penalty, the stripping of their citizenship and potential removal from the country. For someone who has built a family and community here over decades, this secondary civil action carries an emotional weight that far exceeds a standard criminal sentence. It raises the question of whether a crime should result in the loss of one's very identity. The financial and emotional toll of defense. A denaturalization referral is not just a legal hurdle, it is a life-altering event. These cases are federal civil lawsuits that can take years to resolve. Legal fees can easily reach tens of thousands of dollars, a cost that most families on a fixed income or middle-class budget cannot easily absorb. Throughout the process, the individual and their family live under a cloud of prolonged uncertainty. Even if the citizen ultimately prevails in court and retains their status, the financial and emotional strain can be devastating. The mere initiation of such a case changes everything for a family, regardless of the eventual outcome. The two-tier citizenship debate. The broader philosophical concern shared by many critics is that the Scam Act risks creating a two-tier concept of American citizenship. One tier would be for those born in the United States, whose citizenship is essentially irrevocable except in the most extreme constitutional circumstances. The second tier would be for naturalized citizens whose status remains contingent on post-naturalization conduct and subject to revisit by future administrations. This shift challenges the powerful promise of the naturalization process that once you take the oath, you stand on equal footing with every other citizen. If citizenship can be easily revoked, the symbolic and legal permanence of naturalization begins to erode. Proportionality and the role of criminal law. A key question for analysts is whether existing criminal law is already sufficient to handle the bad actors targeted by the Scam Act. Criminal law already provides robust mechanisms to punish fraud, drug trafficking, and other serious crimes through imprisonment and fines. Critics ask whether adding the loss of citizenship on top of these punishments creates a consequence that is disproportionate to the original offense. Proponents of the bill argue that certain acts are so severe they justify this additional consequence, asserting that citizenship is a privilege that must be upheld through responsible conduct. The disagreement ultimately turns on whether citizenship is an untouchable right or a contingent status. Practical steps, documentation, and awareness. In this shifting enforcement climate, preparation over panic is the professional recommendation. The first practical step for any naturalized citizen is to preserve all records related to their immigration history. This includes copies of green card documentation, naturalization certificates, prior visa paperwork, tax returns, and any correspondence with federal agencies. While most people never need these documents again, having a complete, organized record provides a vital shield if an old file is ever pulled for review. Clarity reduces anxiety, and organization builds the confidence needed to navigate a more complex legal landscape. Knowing your rights in 2026. It is also essential for naturalized citizens and their families to understand their constitutional rights when interacting with government agencies. You have the right to remain silent and the right to speak with an attorney before answering substantive questions. You are not required to consent to searches of your home without a warrant. Taking official communication seriously is also critical. If you receive a notice from USCIS or the Department of Justice regarding your status, do not ignore it and do not attempt to navigate it alone. Early legal representation can shape the entire trajectory of a case, and ensure that your rights are protected throughout the process. The future of the American promise. As we look toward the remainder of 2026, the fate of the Scam Act remains undecided in Congress. It may be amended, it could stall, or it could pass in a significantly different form. Regardless of the outcome, the very existence of this debate signals a profound shift in how the country envisions the boundary of citizenship. Citizenship is no longer just a legal document. It is part of an ongoing national conversation about identity, accountability, and equality. For the 26 million naturalized Americans, the best defense is to stay informed, stay prepared, and remember that their achievement in becoming American remains real. Clear information is the most powerful tool we have in these uncertain times.